State of Nevada versus Robert Tellus, PC 368935, present in custody, and this is on for sentencing. The parties want to make their appearances.
Good morning, Your Honor. Leon Willfully and Chris Hamner on behalf of the state.
Good morning, Your Honor. Robert Tellus to Michael Horvath on behalf of Mr. Tellus.
Any legal cause or reason why judgment should not be pronounced against you at this time?
No.
By virtue of the verdict returned by the jury in this matter, I hereby adjudicate you guilty of murder with use of a deadly weapon.
Right here. This is the moment everything turns final. The judge isn't asking a casual question. This is a formal legal checkpoint. When the court asks if there's any reason judgment shouldn't be pronounced, it's essentially the last door left open before conviction becomes permanent. And notice, there's no argument left to make.
Victim 60 years of age or older. Does the state wish to be heard?
Just briefly, Your Honor, thank you. As the court well knows from sitting through this trial, the jury in this case found that Mr. Tellus...
That single sentence carries massive legal weight. Guilty of murder with use of a deadly weapon isn't just descriptive. It automatically triggers sentencing enhancements. Add in the victim's age, and now we're talking about mandatory time before parole is even possible. This is where the math of justice starts stacking up fast.
Willfully, deliberately, and with premeditation killed Mr. Gman. He did it by means of lying in wait, and it was inflicted on an older person. The jury also found that a deadly weapon was used, and Mr. Gman's age was, of course, over 60 at the time of the crime. Essentially, the jury found every single essential fact alleged by the state based on the investigation by Metro detectives. And they found that, beyond a reasonable doubt, after hearing from Mr. Tellus. The court gave him wide latitude to explain and offer evidence of all the hollow claims that he made pre-trial against detectives and elected officials. He made those same allegations at trial.
This is devastating for the defense. When prosecutors say the jury rejected every theory, that means conspiracy claims, evidence planting allegations, all of it failed to raise reasonable doubt. From a legal standpoint, that makes an appeal much harder. Jurors didn't just disagree, they dismissed it entirely.
He alleged detectives planted evidence. He alleged various conspiracy theories involving real estate companies. He claimed various detectives were unethical and that there were several corrupt officials involved in the circumstances he found himself in. The jury squarely and soundly rejected all of that. All of the theories offered by Mr. Tellus were rejected by the jury, and the jury was left with the facts and the evidence that have always been there since the beginning of the case. And that is that Mr. Tellus planned this extensively. He drove to Mr. Gman's house, he was lying in wait, and he attacked him.
This is where the case stops being just about one crime and starts becoming a community issue. The prosecution is framing this as political violence, retaliation against a journalist. That's a powerful narrative, and courts take that seriously because it cuts directly into public safety and free speech. Ask yourself, how does a sentence deter something like this from happening again?
From a place of cover. And of course, Mr. Gman was 69 years old at the time it occurred. The court knows from the evidence in the trial that the planning was extensive. Mr. Tellus used taxpayer-issued resources to look up personal information about Mr. Gman. He scoped out Mr. Gman's neighborhood ahead of time, and then, of course, he attacked someone much older than him by surprise. His reason for doing this, we learned, was that he didn't like what Mr. Gman had written about him. He felt that Mr. Gman had cost him an elected position. This type of violence, this sort of political violence, because of being upset about an article that has been written about you, is unacceptable and dangerous to our community as a whole. Beyond that, Mr. Gman's position as a reporter for decades in Clark County, his death affects the community in a unique way. There are many people who were readers who felt like they knew Mr. Gman and relied upon him to supply them with information about various news within Clark County. And finally, and most importantly, the family of Mr. Gman lost a beloved family member, an uncle, and a brother. Based on all of these factors, the state respectfully asks for the maximum sentencing enhancement available to the court. We do have one victim speaker.
Thank you. Mr. Tellus, do you wish to address the court?
Yes, Your Honor.
Thank you.
First of all, I want to say that the family has my deepest condolences. Mr. Gurman was, very impactful in the community. He made a difference. And we know from testimony by the family that he was a good brother and a good uncle. And I understand the desire to seek justice and have somebody accountable for this. But I did not kill Mr. Gurman. And unfortunately, the people who should be held responsible, who should be brought to justice, the chances of that happening now, right this minute, are slim to none. But that said, again, my deepest sympathies to the family, and I wish them well as they navigate the rest of this tragedy.
Thank you very much. Mr. Paxton?
I'll be brief. Your Honor was very attentive through this trial, which was lengthy. The jury was able to hear the state's case, the defense's case, and they ultimately reached their verdict. We're not here to question the verdict this morning. Mr. Tellus exercised his constitutional right to go to trial and to testify. Period. That's what makes this country so great. This judicial system where we take cases, we take facts, we take theories of prosecution and defense and present it to a jury. Obviously, the jury was very thorough and careful. It took 3 days to go through everything before they reached their ultimate conclusion. Mr. Tellus was convicted. To punish him for doing that, and I'm not anticipating that the court would ever do this, and I'm not saying that Your Honor is, to punish him for exercising his constitutional right is obviously inappropriate. He intends to pursue an appeal. Obviously, again, that's not really for today's discussion. What is his utter lack of criminal history. If you look on page 3 of the pre-sentence investigation report, criminal record, we have a long string of zeros, felonies, gross misdemeanors, prison, jail. He doesn't have any prior convictions. He's not a recidivist that is before this court or others repeatedly being convicted or entering pleas for violent crime, saying, "Judge, this time, give me a chance. This time, things will be different."
Defense attorneys always pivot here. Lack of criminal history, family support, past accomplishments. And legally, those factors do matter. But here's the tension. How much weight should a clean past carry when the crime itself is this severe? This is the exact balancing act judges struggle with in sentencing hearings.
Your Honor heard from his family. He's an exemplary father. He was a good student. He was elected to office. In most part, he was a good husband. We have to look at the entire man. He's been convicted of perhaps the most serious offense. He carries one of the heaviest sentences in our judicial system. The jury elected to give him the opportunity at redemption. There obviously was an element of retribution in the sentence they imposed, but nonetheless they gave him the opportunity to one day be released. What's before Your Honor is, again, how much above that 20-year sentence will he have to serve before he's eligible for parole. Given his utter lack of criminal history, I would urge the court to sentence him to something less than the maximum. The maximum sentence, we can't stack these enhancements. Maximum sentence would be an additional 8 to 20 years. I'm going to urge the court to allow the parole board a bit more discretion. I would urge the court to consider a 1 to 10 year enhancement, which is allowable under statute, and allow the parole board to determine when he should be released. Of course, it's a two-step program. Number one, he'd have to be eligible for parole on the murder count, which won't occur until 20 years is served, but then there's the second consecutive sentence that must be served for the enhancements. I would urge the court to impose a sense of leniency in that he has no prior criminal record. Mr. Tellus has been actively engaged in his defense since the get-go. that continues through today. Again, I would urge the court to not hold that against him. And based upon what the evidence Your Honor has heard, the statements of the parties, our arguments, and the information contained within the pre-sentence investigation report, which I just want to put on the record, there's no Stockmeyer issues. We'd submit it to Your Honor's sound discretion.
Okay, thank you very much. You may call the first witness.
Gman.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state and spell your first and last name for the record?
Sure. Jay German, Jaygerman.
Thank you.
Good morning.
Good morning, Judge. Thank you for allowing me to just talk a little bit. Yeah, we lost a brother. We lost an uncle, a friend, a leader. We're still in shock, and it's been 2 years. And I mean, it's going to take a long time to recover from this. It's taken up this whole ordeal, the trial, the crime, the murder. It's taken a big toll on our family, and it's been immense. It's been really difficult for all of us. We're doing our best to get through it. We really are. But he was our leader, and we're never going to see him again, and it's hard to come to that realization. But we're dealing with it. It's just going to take a long process for all of us, to recover. And we're struggling with it, but we're doing the best, and we miss him dearly. We really do.
And this is the final number, 28 years to life. That means parole eligibility is possible, not guaranteed. Every future hearing will reopen this tragedy for the family, forcing them to relive it again and again. So here's the real question for you. Does this sentence feel like justice or just a legal system doing the best it can with irreversible damage?
We've had a couple of his birthdays since he's passed, and it's nice to get together as a family and, kind of visit with Jeff. But it's not the same, and it never will be. We've lost a lot. He lost a lot. We have a lot of anxiety about the future safety of our family, and the children of our family, if Robert Tellus were to be released after just 20 years of incarceration. But thank you for letting me take a few minutes to talk about Jeff and our family.
Thank you. And thank you for your testimony. Anything else?
Not on behalf of the state.
Okay, in accordance with the laws of the state of Nevada, this court does now sentence you as follows. In addition to the administrative assessment, the DNA fee, and the collection fee, you'll be required to submit to genetic marker testing. At this time, the court's going to sentence you to life in the Nevada Department of Corrections with parole eligibility beginning after a minimum of 20 years has been served, and after considering all the factors enumerated in NRS 193.165, the court's going to sentence you to a consecutive 8 to 20 years for the deadly weapon enhancement, for an aggregate 28 to life. In the Nevada Department of Corrections, he has 771 days. Does the defense agree with that?
Yes, we do.
Okay, and the restitution, was there any objection to the restitution amount?
No, Your Honor.
And the proposed restitution, the amount of $23,347.71 to the victim's family.
Thank you.
We do have two housekeeping matters. One, there was a request for return of property. I've reached out to Mr. Hammond. We anticipate an order being signed to return items that were seized that were not of evidentiary value to Mr. Tellus' family. Secondly, we filed a motion to withdraw. There's not been a breakdown of communications. We've had a very good level of communication and participation from Mr. Tellus and ourselves through the course of this case. We were retained for trial in this matter. Obviously, now the case is going to the next stage. I visited with him yesterday. He's aware of the motion, which we gave him a copy of this morning. I know we have a representative from the Public Defender's Office here. Obviously, there's an appeal that's going to be pursued. We want to bring that to the court's attention. I would ask that Your Honor grant our motion and set the matter for a status check in a week for confirmation of appellate counsel. And that's I don't believe there'll be an opposition from or an objection from the state in reference to our request.
Okay, I think
Or from Mr. Tellus.
someone here from the Public Defender's Office.
Yes, good morning, Your Honor. Kathleen Curry-Diamond from the Public Defender's Office. We're ready to accept confirm as counsel today. So,
Okay, and is that your desire, Mr. Tellus?
Yes.
Okay, so I'll grant the motion to withdraw. The public defender is appointed.
thank you, Your Honor.
I think that's it. Thank you.
Thank you very much.
for hearing.
Thank you.
Absolutely.
Thank you, Your Honor.
Mr. Singer?
Come on, Your Honor.
See.